Hi, this is Hesper Hyman, and this is my presentation on tort liability. So first, we need to define what is tort liability. A tort is something you sue someone for doing to you. There are two main types of torts that we see that mainly pertain to schools, and this is going to be intentional tort or negligent tort. So what is intentional tort? With intentional tort, you just have to intend to affect the other person and harm results from your actions. There are four main types of intentional tort that we see. They are assault, battery, false imprisonment, or defamation. Negligent tort is negligence is where somebody doesn't do something they were supposed to do, such as stop at a stop sign, and harm incurs. There are three parts to a negligence case. This is duty, breach, and causation. So looking at some cases of some schools that involved tort law, first is Frame versus Comac. Frame was an 8th grade student, with Comac being a science teacher. Frame was disruptive during the classroom, and so he was being asked to leave. He refused to leave. So at the time, the teacher was grabbing his arm to help him leave the classroom at the same time he stood up, which incurred him stumbling, falling into a wall. His parents filed a lawsuit against the teacher in the school concerning battery. The courts did find that the teacher was justified in what he did, that the students had sufficiently provoked him to forcefully remove him from the classroom, and the courts also found that it was necessary for the teacher to remove Frame not only to maintain order, but also to facilitate the learning process for other students. So looking at my own school system, what are some ways that we would measure reactive, proactive, and then our professional ethics? So in reactive measures, in this instance, of course, the teacher would be questioned. The students might be questioned about what happened. Pending the investigation, the teacher might be asked for a leave of absence, whether paid or unpaid. Disciplinary action, probably against the teacher for putting hands on the student. And there also could be disciplinary action against the student for not listening to the teacher, refusing to leave when they were asked. So some proactive measures were professional development on how to handle a disruptive student. How do we go about getting a student, the person should have probably called the office, had somebody come down from the office or administration to pick up the student, something like that. And then it wouldn't hurt to have a professional development on what tort law is. So when we look at the professional ethics, teachers need to understand that grabbing or restraining a student is never an option unless it is a justifiable restraint by a certified personnel. So, it's very important that teachers understand that we need to look for other options for students to be taken out of our room. It's not okay for us to grab their arm, for us to try to maneuver them, that not only will the student possibly get hurt, but we could as well. So Flanagan versus Canton. Flanagan was a 5th grade student who was in a locker room, and Canton was the coach. And Flanagan was pushed in the locker room by another student. He did sustain injuries that required him to have surgery. Apparently, the students had all been rowdy in class all day, and the coach, Canton, had gotten onto them, also having a talk with them. When the injury occurred to Flanagan, Canton was not in the locker room at the time. It did say in the briefing that he normally was in the locker room, but this time he had stayed out for a couple minutes while he spoke to another student. So the mother sued for her son's injuries that resulted of negligent supervision by the teacher. While the schools did find that a school is only liable for foreseeable injuries sustained by a student that were caused by an inadequate supervision, they did end up siding with Flanagan, stating that because of the rowdy environment that had happened early on, Canton should have had a greater duty of supervision because he understood what was going on with the students. So reactive measures. A teacher would be placed on leave pending investigation. And then ultimately, I believe that the teacher would be fired for negligence. Some proactive measurements, professional development on how important supervision is for students at all times, and then make sure it is clearly defined in the employee handbook what is supervised versus unsupervised. So when we look at the professional ethics here, teachers have a professional duty to supervise and protect students while they are on school grounds at all times. There are unforeseeable incidents that can occur, but students should never be left unsupervised in any room. The next case is Munn versus Hotchkiss School. Munn was a student that was on a hiking field trip when she was bitten by a tick that transmitted encephalitis, which caused her serious neurological damage, leaving her permanently unable to speak. The parents filed a negligence suit against the school because it said that they were not informed of the dangers of there possibly being ticks in the environment. They were not informed of what protective clothing they should have provided for their student, insect repellent, all of those things. Apparently, this was a trip that the school took all the time. And while the court said that this was a rare occurrence, that the school did not prepare the students and ultimately the parents for being able to safeguard their child. The courts did find in favor and awarded $10 million in economic damages and $31.5 million in non-economic damages to Munn. This did go all the way to appeals, where it was reaffirmed that the $41 million was due and that the school was found liable. So some reactive measurements that I would think of that would happen. So first of all, when this happened, I would think that the school would want to suspend all field trips until we could review, where was the breakdown, what needed to happen to make sure that this incident like this didn't happen again, such as a release form needed to be changed. And then, of course, as a district, they're probably going to want to appeal this decision as far as they can. Proactive measures, rewrite parental release to limit liability and use a lawyer. You want to make sure you use your school lawyers to help get the wording correct on that parental release. And then train staff on insect bites and first aid. So the professional ethics, field trips, we know, are an extension of the school's learning environment, and then such students have the same expectation of protection. So if we would protect them in the classroom, it's the same way we need to make sure that we're protecting them outside of the classroom. While there are unforeseeable accidents that can occur, we need to make sure that we're doing everything to limit those accidents. In this case, they should have had maybe a flyer or something that talked about, what can happen if you get bit by a tick, or, different things like that. So Pierce versus Herney Independent School District. Pierce was a junior at high school where the agricultural teacher had an ATV that he brought to school, and then they would use that to move supplies down to the ag farm. Well, on one day, the ag teacher asked Pierce to take the ATV with another student to take some tools to another part of the farm. On the return trip, Pierce lost control of the ATV, crashed into a tree, and he died from blunt force trauma. Now, this is where this one gets a little interesting, because I haven't done enough research yet as to if other states have the same law, but because this happened in Texas school districts, the state law gives Texas school districts immunity from liability in tort laws unless the claim relates to property damage, personal injury, or death arising from the operation or use of a motor-driven vehicle. Now, here's where it's interesting. Under Texas case law, the motor vehicle exception applies only when a government employee is driving the vehicle involved in an accident. So because of that, the parents, while they did sue the school for negligence, and they could not, the courts dismissed it because of this law in Texas. They did take it on to appeals, where the appeals court also said allegations did not suffice to show deliberate indifference difference. So they were not able to sue the school. So some reactive measures in this instance. First, there needs to be some type of disciplinary action for the ag teacher. Sending a student off alone on a motor vehicle of any kind is just not acceptable. You don't have control of the environment. There's too many things that can go wrong, and I just don't feel that it is the safest environment in that situation. That ATV definitely needs to be removed from schools, since it is the teachers, the ag teachers' personal and not the school. So it never should have been there in the first place. So proactive measures. Update the employee handbook about transporting or allowing students to use ATVs during school hours. So this would deal with any type of vehicle. Do students have any right to those vehicles, or do they not? Make sure that there are permission slips if students do use the ATVs. So if there are ATVs that the school is going to be using, we need to make sure that parents are aware of it, that they have signed off on that, and that they've signed off on the liability of that. So the professional ethics here that we're looking at, students should not be using motorized vehicles or equipment without proper training. They should also not be unsupervised. They also should not be doing it without proper protective gear. So just like we have protective eyewear in the wood shop, if our students are using a motorized vehicle of some kind, they need to have the same protection. The next case is AB versus Rhinebeck Central School District and Thomas Mahoney. This was a sexual harassment case by 4 current and former high school students and school employee against the district and Principal Mahoney. They alleged that Mahoney sexually harassed the 4 students as well as the female high school students during his 10-year tenure at the district, which violated Title IX, acting with deliberate indifference to known sexual harassment of other students. So this case, then, the court approved a consent decree that requires the district to develop and implement a comprehensive plan that will ensure a discrimination-free educational environment for all students. Lastly, the district must pay $152,500 to compensate the student victims and to pay their attorney's fees. Now, what's different here is just because a court approved a consent decree did not mean that they actually found the school district guilty. So it's more of that the school did not fight on this, and this is kind of a way of getting it fixed without there being an actual guilt or innocence labeled. So reactive measurements, of course, first, the principal needs to be removed from duty immediately, pending the investigation. And then, of course, the principal definitely needs to be fired for sexual harassment. Some proactive measures that we need to look at is professional development on sexual harassment training and prevention. Maybe have community and student meetings on how to report harassment of any type. Have bullying or harassment reporting forms available in person and on the school website. And then your professional ethics. Schools have an obligation to protect all students from bullying and harassment. I can't say that this principal got away with this for 10 years and nobody saw anything going on. So it could have been that somebody saw something, or somebody may have reported and somebody dropped the ball. So we need to make sure that all students feel comfortable. If they can't go to the current principal, then who is the next backup? Who do they need to talk to make sure that things are being done if they have concerns about sexual harassment or discrimination of any way? So that's the end of my presentation. Thank you so much for watching.